Hello guys, and welcome to my lecture. In this class, we are going to continue the exceptions to the rule that the board of directors shall manage the affairs of the company. That's the business of the company. In the previous lecture, I stated the first rule, the second rule, the third rule, and the fourth rule. Today, I'll be stating the fifth rule, the sixth rule, and the seventh. All these rules are in form of exceptions. Now, starting with the fifth exception, we have to look at section 87.5b. And what does section 87.5b say? It says that notwithstanding the provisions of subsection 3, the member in general meeting may institute legal proceedings in the name and on behalf of the company if the board of directors refuse or neglect to do so. Now, you see, this provision is such that it's quite confusing because to a particular extent, the Act has given the board of directors the power to do certain things. For example, institute proceedings. If the articles have given the board the power to institute proceedings, inherent in such power of discretion of instituting proceeding is also a discretion not to institute. If you are giving me a thing and you are telling me that I have the discretion to do something, it implies that since I have the discretion to, I therefore have the discretion not to. Do you understand? So when they say that there is a refusal, since I have a discretion not to, what then will constitute a refusal? A refusal means that there must have been a direction. If there is no direction, there can be no refusal. And do not forget, while I was arguing in the recalcitrant clause in section 87.4, I stated that you cannot direct me or instruct me when the power is on me. I have the power. I am the one, according to the law, who is supposed to do this thing. If I'm the one that is supposed to do it, who are you to direct? Who are you to then instruct? Do you understand? So in this case, the board of directors are the ones that are saddled with the power of instituting proceedings. Therefore, how would the general meeting therefore tell the board that they refused to? Do you understand? So it's kind of very complicated trying to explain. The only time there can be a refusal is where there is higher authority, like the court, or maybe the articles had placed the general meeting in a higher pedestal. That means giving them so much power, including the power to institute proceeding. Then in this case, where there has been a direction from the general meeting coming down to the board, then we can say that there has been a refusal. Where there is such refusal, then the general meeting can then go and institute an action. But solely on the board, who has the power already to institute, you cannot say that the board refused because you cannot direct someone who has power. But the other part, which is refusal or neglect, who interprets what a neglect is? Where, in what circumstance can we say that there has been a neglect? You see, that also is kind of difficult in trying to interpret. But this would also constitute exception number 5 to the powers of the board of directors to manage the business. Now we are going to exception number 6. And exception number 6 can be found in 87.5c, section 87 sub 5c. And what does it say? Notwithstanding the provision of subsection 3, the members in general meeting may ratify or confirm any action taken by the board of directors. It is going to be instructive for us to look at the case of automatic self-cleansing filter syndicates versus Cunninghame, where the court held that if board of directors is acting within its power, there is no need for ratification. It is therefore submitted that this provision should only apply where the board of directors is acting outside its power in the act or in the articles. That is the only time that the general meeting can ratify. Basically, if the board of directors act without authority or in excess of its authority, the general meeting can always ratify. Do you understand what this provision and this case is saying? We are basically talking about the board of directors. Now, you are saying that the members in general meeting should ratify the act of the board of directors. The only time there can be a ratification is where the board in itself has done something outside its powers. If it hasn't done something outside its powers, there cannot be a ratification. You can only ratify where somebody has done something outside what he was supposed to do. You cannot ratify where the person was acting within authority. Do you understand? I would like us to also look at the case of BAMFORD and BAMFORD. In that case, there was an allotment of shares. The directors allotted shares, but they allotted it with improper motive, therefore breaching the fiduciary relationship that they had with the company. The general meeting passed a resolution that ratified that particular act. When they took the matter to court, the trial court said, oh, the board of directors has acted outside its power. By acting outside its power in that context, meaning improper motive, acting with improper motive. Therefore, the members in general meeting could ratify where the board of directors had acted with improper motive. But when they took the case to the Court of Appeal, although they arrived at the same conclusion, but it was from different approaches. Now, the Court of Appeal said you cannot ratify something that it is within someone's power to. Do you understand? It can't be termed the ratification. That is what we can find in Cunningham's case. Did they have the power of allotment in the first place? That is the question. And yes, they did. However, they did it wrongly. It is such wrongful act of allotment that could be ratified because it makes it not a void transaction, but a voidable one. Voidable to the extent of the general meeting. Do you understand? So you need to understand that when we are talking about ratification, ratification can only be done when you exercise powers that has not been given to you. In BAMFORD and BAMFORD, the directors had the power to act. They had the power to allot. Where you have the power to allot, there can be no ratification. However, where there are improper motive, as the Court of Appeal had said, it is such improper motive that you can say you want to ratify, not the power to allot in itself. Do you understand that? And that is that for the sixth exception. Now we are getting to the last exception, and that can be found in section 87 sub 5D. What does it say? It says that notwithstanding the provision of subsection 3, the members in general meeting may make recommendation to the board of directors regarding actions to be taken by the board. You see? So in this case here, we are talking about making recommendation. I do not personally see this as an exception, but it falls under what to be regarded as exception. So in its totality, we have 7 exceptions to the rule that the board of directors shall exercise powers and manage the business of the company. Now we are moving further. We are going to interrogate the case of Virgin Tech versus Mohammed, and also the case of Odutola Holdings versus Ladechobi, as it covers basically almost everything I've taught regarding the organs of corporate administration so far, as this is the introduction. We are going to look at this perspective, that perspective, managing director, where the company acts this and acts that. Just make sure that you watch my next lecture. See you there.